Good morning and welcome to this fourth guest lecture on comparative constitutional law. We have the pleasure today of hosting Professor Roberto Toniatti, who is Professor of Comparative Constitutional Law in this faculty. And next year will be your professor in the course of multi-level protection of fundamental rights. He has, as you know, he has kindly accepted to change the title, the original title of his lecture, with a view to offer a presentation on ongoing developments on Spanish constitutional law. The title of the lecture today is The Constitutional Crisis in Spain and the Catalan Question, Work in Progress. The aim of this lecture is to illustrate the legal coordinates and to explain the current Spanish constitutional crisis. It is really an attempt we are trying to understand better, to explain what's going on from a particular perspective, which is not the only perspective from which we can look at this phenomenon, which is the legal perspective. In this short introduction, I would like just to situate the argument in the broader perspective of our course. It is definitely a lecture dealing with the unit on federalism and regionalism. We have already touched upon Spain as an example of a regional system. And we have also said in discussing the Spanish experience that the center-periphery relationship, the regional question, has always been one of the most controversial issues in Spanish constitutional law and in the adoption of the 1978 Constitution itself. It is also important to remind that from the start the Spanish Constitution has embraced the idea of an asymmetric regionalism, although the development of regionalism has not really or entirely followed that trajectory. We have mentioned that there has been a process of equalization, in particular in the 90s, and perhaps we can look at this as one of the background issues that has triggered the current crisis. But on this, of course, Professor Toniatti will be more articulate and exhaustive than what I can be. The Spanish constitutional crisis can be viewed from the perspective of regionalism, but it should also be viewed from another perspective that we have investigated in one of the first units of the course. And I'm referring in particular to the unit on constitution making and constitution amending. We don't know now, we can't predict what will be the outcome of the crisis. It is a work in progress, as it is stressed in the title. But one of the possible scenarios, perhaps a less likely scenario, but we never know, is that we will notice an emergence of the constituent power in one of the most dramatic forms, which is the revolution-based adoption of a new constitution. Revolution-based because there is a clear and open break with the previous constitutional order, the Spanish Constitution. And also this perspective must be taken into account, must be considered, and if we take this perspective, we can conceptualize what's going on in Spain as probably a clash between two different perspectives. The one of the Spanish government trying to reaffirm the rule of law under the Spanish Constitution, and claim, the political claim, and perhaps one day the legal claim of the current Catalonian government to establish a new political and legal order, a new political community, sovereign and capable to exert in a fully fledged way its right to self-government. So if this is the perspective, the lecture that Professor Tonetti is going to give us today will be also a lecture on the role and the limits of the law. The law is a way to explain the reality, is also a way to regulate and to try to modify the reality, but it's not the only variable we can take into consideration. Roberto, the floor is yours.
Good morning also on my side, and thank you, Marco, for the invitation as well as for the introduction, which has already focused the approach which I'm going to give to my presentation. I would like, first of all, to go through the title of this class, and also I would like to ask you to raise your hand and ask questions or make comments also along the way. I don't really know how much I'm going to talk. I generally talk a long time, but I do want to have a break, so you will have a chance of resting. But also at the same time, I would like to have some sort of dialogue. Also, because I think that in front of a phenomenon such as this, even though we are not from Spain or from Catalonia, but we are from Europe, or anyway we live in Europe, and we may be taken also by some emotional feelings. I don't fear to admit that because of the fact that I've been teaching at one of the universities in Barcelona for the last 7 years, I do feel very close to the Catalonian or to the Catalan population. Although, of course, as a lawyer and as a constitutional lawyer, I cannot but share the main opinions according to which we are here in front of a clear breach of constitutional law. The point is, as Professor Dani has suggested, that we are not facing a phenomenon which can be exhaustively explained and analyzed according to an approach of legality. We need to be also sensitive to the approach which includes the dimension of legitimacy. And I'm quite sure you have gone through some differences between legality and legitimacy during your course. Not yet, I'm sorry. So we anticipate something which is fairly important. But certainly, you're a first-year student, aren't you? Yes. And this is your first and only public law course, correct? Right, okay. So let me just say, and I'll let it to your capacity of intuition, there is a difference between legality as conformity to written law and legitimacy as conformity to higher law principles. Racial legislation in Italy in 1938 was absolutely in compliance with the requirements of legality. It was adopted by Parliament, it was signed into law by the King, it was published on the official Gazette of the Kingdom of Italy, so legality was fully satisfied. My question to you, and this is why I say to rely on your intuition, would this be also legitimate? What was legal was also legitimate, or are there some higher law principles that would undermine the foundation of racial legislation in Italy. But anyway, this is just, for your intuition. So, my title, A Work in Progress, as was already indicated by Professor Dani. The lecture is meant to provide not a detailed analysis of or compliance or non-compliance with the number of act decisions. I have them all here. Decisions by the Constitutional Tribunal of Spain, decisions by the government of Spain, decisions by the government of Catalonia, and also some judicial proceedings of different sectors of the judiciary in Spain. So I'm not going to do that. Of course, that is interesting. Of course, all such deeds may be criticized, but it is also true that lawyers in Spain are very careful and well trained. So it would be difficult to say, "Oh, here you broke the law." No, I'm afraid, and that everything's erased from the point of view of legality. So I'm not going to do that. But I'm trying to give a framework of reference, the coordinates, as Professor Dani said, based on a few main coordinates that will contribute to found one's own opinions on the issues involved. So in other words, what is important here is not my own opinion, but that you are able to grow your own opinion. As a matter of fact, I have already told you my opinion. I find the Declaration of Independence against the legal order, and yet I sympathize not with the Declaration of Independence, but with the quest of Catalonia for more autonomy, more self-government. So this is why it is a work in progress. Secondly, constitutional crisis in Spain. Now, I don't like to talk of the Catalan crisis, because I think that there is fundamentally a constitutional crisis in Spain, which is connected to the inability of the state of Spain, of the government of Spain, to manage and control the Catalan question. And this has very much to do with party politics, has very much to do with short-term electoral gain. Consider that there is no stable parliamentary majority in Spain. In the last 2 years, they had to vote 3 times because there was no coalition available. And so there was, for months, Spain has been without a government which was not a caretaker government. We are in a system in which, again, in the last 2 to 3 years, 2 strong political parties have emerged, Podemos on the left and Ciudadanos on the right. In particular, I would say it is interesting to examine Ciudadanos because it is a center-right liberist political party which is the outcome of the reaction of part of the population to the scandals and the corruption of the Partido Popular, which is the party with the relative majority of seats in the Cortes, in the parliament. So just to show to what extent the 2 older parties, the Partido Popular and the Socialist Party, which has as an acronym PSOE, Partido Socialista Obrero de España. These 2 parties are absolutely, I don't want to make any comparison with Italy, but you know what I mean. I mean, all the parties are being stimulated to renew, sometimes they do, sometimes they don't, by new political formations. And so because of these and of course, don't forget that whatever the large political parties do from Madrid against Catalonia is by all means meant to capture the electoral consent of the rest of the population of Spain, and of course that is the majority. So it is very important not to lose the support of the great majority of the population. The population is, and I'll go more into detail in this, is and has been now for the last 10 years quite against the claims of Catalonia. And we are, or many of us may be familiar with the fact that the large number of either Italians or Italian members of parliament are against, for instance, the special autonomy of some regions. So you can understand also the same kind of feelings in Spain. Let me just tell you that 2 or 3 years ago, I think 3 years ago, there was a movement in Spain that suggested to boycott the Catalan cava during the Christmas and New Year celebrations. Now the cava is the sparkling wine, lo spumante. And of course the cava from Catalonia is the best in Spain, is very good in itself. And just to say, to what extent there were clashes that were even elaborated on such rather trivial questions. So the idea is that the crisis the constitutional crisis is a Spanish constitutional crisis because the central authorities have not been able to reason in an etatist perspective and agree on some sort of negotiated referendum, as it happened in Scotland with the Scottish independence referendum, or as it happened in Canada with the Quebec independence referendum. All such referenda, by the way, having not received the necessary majority. So, and then the second element is the Catalan question. Of course there is a Catalan question, which has to do with the quest for an ever more satisfactory solution to both the issues of cultural identity and self-government, because this is the Catalan question. It is not only self-government, autonomy, but it is autonomy which is related and somehow caused by a very sheer awareness of a distinct identity. If you ever go to any Catalan, no, of course, because you're first here, but if you go to any Erasmus exchange program in Catalonia, you will see that a good part of the teaching is in Catalan. I remember the very first years, many students from Trento went there and they complained, but that's Catalan, that's not Spanish. Well, it is Catalan because that is Catalonia. And it is also good, of course there are teachings also in Spanish, and you can always choose the teachings in Spanish, or you can get your opportunity and learn some Catalan, which is a language which is, I would say, very much between Spanish and French. And for Italians, it's quite easy to read Catalan, although it is less easy to understand it. So let's see the origins of the Catalan question. There is undoubtedly a Catalan question, and I would say that the Catalan question is a paradox of a success story. A success story which starts in 1931. I know that with Professor Dan you have already spoken of the constitution of the Second Spanish Republic, which for the first time organized Catalonia as a unit of self-government and in a way that was respectful of their language and cultural identity. But then, of course, the Civil War eliminated all this. The former, or if you like, the last president of Catalonia during the Republic was executed, I think in 1940, by Francoist forces. So, of course, that gives you a very clear idea of how much repression took place in order to deal with the Catalan question. Then, of course, in 1975, the process of return to democracy of Spain has started. In 1978, there has been the present constitution, the democratic constitution of Spain. And in 1979, just 1 year after, we have the first statute, which you call statute of autonomy. I prefer to call it charter in the sense that it is not only a statute, it is something more. In Italian also, the statuto of a region is, of course it is a law, but it has its own name as Statuto. So the success story turned into an institutional disaster, because I find that what we have now is an institutional and political disaster. So let's see the origins of the Catalan question. At an early stage, out of Francoism, I have already mentioned the execution of the last president of the Second Republic. And the way out of Francoism has been a very interesting example of constitutional transition which takes place through the rules of the previous constitutional regime. You may have seen this already. In fact, this was called ruptura pactada, which I have here translated as negotiated way out, and it was negotiated between the bunker, the way it was called. It was the stronghold of Francoist that rested very much on the police, on the Guardia Civil, on the army, and on the Catholic Church. The bunker, and of course the movement of Franco. And on the other side, the parties which had established themselves after the death of Franco in 1974. Now, the status of some regions, certainly of Catalonia and the Basque Country, has played a major role in the ruptura pactada. In other words, the pragmatic compromise that exchanged an authentic transition without any criminalization of the former ruling class included protection of minorities, and we shall see that there is one, but you have seen read Article 2 of the Constitution, where reference is made to regions and nationalities within the Spanish nation, which is unitary. This is a very good example, you understand, of pragmatic realism in ending a negotiation. But then there has been a gradual development of Catalan unrest. Now here, let's go more into details. Now in the Cortes, the Parliament of Spain, as a result of the 2004 elections, there was a majority of the Socialist Party, the PSOE, supported by some parties from the regions and the Catalan members of parliament who were supporting the PSOE government. Now, at that time, Catalonia started suggesting that they wanted or needed to go beyond the 1979 Charter or Estatut. And the Socialist Party agreed and started to elaborate amendments to the Constitution, here we are, that would accommodate the claims by Catalonia. Now, of course, amendment of the Constitution requires larger majorities, and here we have the strong opposition by the People's Party, by the PP, El Partido Popular. Of course, you understand, the Catalans were supporting the PSOE majority, the PP was at the opposition, and therefore it didn't want, even indirectly, to support the PSOE government. Mind you, the Spanish Constitution does not have an eternity clause, and also provides, as you know already, for a total revision. So there would be no constitutional limitation on the possibility of accommodating the claims by Catalonia. As a matter of fact, even the Constitutional Tribunal of Spain went as far as saying, you want more autonomy? Amend the Constitution. But of course, in order to amend the Constitution, you need the proper quantity, let's put it this way, of political support. and this was not achieved. By the way, you certainly know it, but the Partito Popular is the political party of the present Prime Minister, Mariano Rajoy. So, not being able to amend the constitution with the support of the Socialist Party, Catalan authorities decided to take a different way, that would be to change their statute, their charter, and to amend it in a way that would enlarge the self-government and the acknowledgement of the peculiar cultural identity of the Catalan population. Now, this was done in 2005 when the Parliament of Catalonia approved the new statute, the new charter. Then, according to the procedure established in the Constitution as well as in the Charter, the draft new charter needed to be approved by the national parliament through the special majority of a ley organica. You know right about ley organica, which requires a qualified majority, not 2/3, but the absolute majority of the members of both houses of parliament. Now, even this raised the opposition of the PP, of the Partito Popular, and they have chosen two ways. The first was to collect signatures of citizens expressing their opposition to the new charter for Catalonia. Now, this is the period in which they even suggested to boycott the sparkling wine from Catalonia. But they also used the second way, which was, if you like, the judicial or the challenge of the constitutionality of the ley organica that approved the Charter of Autonomy of Catalonia, and this is again according to the rules. What is fairly unusual is that the Constitutional Tribunal invalidated a number of provisions of the new charter, but this, I would say, is business as usual. But business is not as usual when you think that the Constitutional Tribunal took 4 years in order to deliver this decision, which means that for 4 years the ley organica was in effect, was implemented by national and Catalan authorities, precisely because the decision-making process within the court took such a long time. So there has been, and we shall see more in detail, the partial invalidation. Certainly there was an emotional reaction by the Catalan authorities and population. And of course they said, and here of course I take distance as a lawyer, judicial decision is against the will of the people expressed through the referendum. I forgot to say that the final step in the decision-making process of the ley organica was a people's referendum which endorsed the new charter. So here you have the will of the Catalan, parliament, the will of the national parliament, the will of Catalan voters, but that's not enough for lawyers. We know that. If the charter is unconstitutional, it is unconstitutional in spite of all the overwhelming majorities and support that it may receive. But you understand also at the same time that the reaction has been very emotional. They say, this is against the people of Catalonia. And that, of course, was a very strong fact that endorsed and strengthened the movement for switching from more autonomy to independence and sovereignty. Initially, though, the emphasis was on the right to decide, dret a decider. That was the right to decide In other words, the right to have a referendum, not to have a referendum. So there was a sort of intermediate passage. We Catalans want to be given a chance of expressing our view. And in fact, when the Spanish executive, the Spanish government, was against the right to decide, the Catalans said that the government is violating their freedom of expression, not that it was violating their constituent freedom or a political right. It was a freedom of expression. So it was, if you like, an initial stage. Of course, once they have expressed the will to make a secession, then of course part of the job is done already. But certainly, from the formal point of view, the right to decide doesn't entail any final decision. But if you like, is the first step of a process that may ultimately lead either to negotiation in order to avoid independence or to the proclamation of independence as such. So this is quite important. And then we know the story. The right to decide has not been acknowledged in any way. By the way, since then the executive has had Mariano Rajoy as its chief, and has been mainly supported by the Partido Popular with an absolute majority in the first years, and now with the support even of the Socialist Party, just because they are unable to create some coalitions. So there has been a fake referendum the first time, and then you had elections that were given the meaning of endorsing the support of the majority of the population for secession. And then you have the formal referendum of October the 1st of this year. And here you have, you have the final, if you like, violation of the Constitution. Because that was meant to be a referendum not as an expression of the will, but as a decision-making. And in fact, the law, the Catalan statute that activated the referendum, made it mandatory for the Catalan parliament to declare independence not later than 14 hours after the voting in the referendum, irrespective of any majority of the people who were participating in the referendum, or even without a clear majority, 50% plus one. So if the yes vote was overcoming the no vote, the Catalan parliament was forced to declare independence, which is what happened, as you know. Now, all this is absolutely a manipulation, I would say, of a correct application of the law. This is, I wouldn't have any other name for than manipulation. The consequence of this is, as you know, the enforcement of Article 155 of the Spanish Constitution, which means a suspension of self-government. So you understand why I said from a success story to a political institutional disaster, because this is what you have, the suspension of self-government. And Article 55, as you see, if a self-governing community, a comunidad autónoma, does not fulfill the obligations imposed upon it by the Constitution or other laws, or acts in a way that is seriously prejudicial to the general interest of Spain, the government, after having lodged a complaint with the president of the self-governing community and failed to receive satisfaction, therefore, may, following approval granted by the overall majority of the Senate, take all measures necessary to compel the community to meet said obligations or to protect the above-mentioned general interest. Now, as it is written, this provision is fairly respectful of some procedural guarantees. Of course, it is very vague, very generic acts that are seriously prejudicial or fulfill the obligations. This is fairly, but this is exactly what happened. And this is a typical area, let's say, of political discretionary evaluation. And the Senate is somehow the chamber that should represent the territories, although it is not really so. So, we're still debating the title, no? Constitutional crisis in Spain, the Catalan question. You have now, I hope, a more deeper understanding of the Catalan question. And so you understand that we are in front of a work in progress, and in fact there is a twofold work in progress. One is judicial, in particular the enforcement of criminal law on those who are responsible, politically responsible for what happened, including the head of the autonomous police force, the Mossos d'Esquadra, and also a political process, and the political process is to be identified with the elections that the national government has called for December the 21st of later this year. And this, of course, will be fairly important, and the preparation for the elections are going to be a new chapter to be strictly examined. By the way, tonight at midnight is the deadline for presenting the list of candidates. And so it will be very interesting to see what happens, in particular if President Puigdemont will be a candidate, as everybody is certain he will. And it is interesting to find out whether the Spanish government will introduce any restrictive legislation, although unless they do it today in the afternoon, they should do it after the deadline has expired, and this would be certainly to be regarded as unconstitutional. Yes.
The government called the elections as exercising Article 155.
Oh yes, I'm sorry. I thought it was clear. In a way, I mean, all the institutions, the autonomous institutions of Catalonia have been suspended. There's no president. The president is in fact the Prime Minister, Mariano Rajoy, who is acting through a deputy Prime Minister, a very aggressive lady. There's no parliament. All decisions are taken by the executive in Madrid. And also the decision to call for the elections. Of course, on the 21st of December, the idea is that on the 21st of December, a new parliament would be elected that will give confidence to a new executive, and that the new parliament and the new executive will develop different policies. But of course, this is a big question mark. A big question mark. So, any questions so far? Because we have 10 minutes before the break. So we have seen the origins of the Catalan question. Now let me examine with you some of these of the coordinates that were mentioned earlier. That is, some lenses through which it is inevitable that we try to examine the Catalan phenomenon. First, the national component of the nation state and the protection of national minorities. I've been mentioning a number of times the fact that Catalans are a language minority, a cultural minority, which have gone through centuries of partial self-government. Of course, before the nation state, it was the whole scenario was quite different. But certainly the Catalan language has always been spoken. It is a language with, let's say, literary dignity, and there is a historical, cultural identity. Now, in Spain, when you speak nowadays of nationalism, inevitably the connection is made with regional nationalism. You don't speak any longer of a Spanish nationalism, which in fact does exist, and it is quite strong, more or less, as the Italian nationalism. But nationalism is the word which is now always related to regional parties, in particular to Catalonia and the Basque Country. So also from the point of language, there has been an important shift. Now you see, this is quite interesting because when people in Madrid rally in the street and shout, Catalonia is Spain, Catalonia is España, you understand that there is a great danger, because let the Catalans say that Catalonia is Spain or not. Because if it is Spaniards who say that Catalonia is Spain, it is just a manifestation of Spanish nationalism. It is again the overwhelming power of Spain, which is trying not only to incorporate Catalonia, to assimilate the population, but even to deny that there is a separate and distinct identity. So this, I would say, is a very dangerous thing. Of course, when we try always to remember the reality of the minority protection and the national component of the nation state, we have to recall that nation states always have had in history, in European history, and not only, a nationalistic approach. And the nationalistic approach was one that was supporting uniformity of rules, uniformity of language, uniformity even of religion. You may know, or you may not know, that in the Peace of Augusta, a principle has been introduced into European international law, and the principle, which is quite, which makes you shrink, I would say, is cuius regio eius et religio. That means, if you are a citizen of this country, automatically you are either Protestant or Catholic. This way was, in a way, almost a liberal provision after the Reform and the wars of religion, which established the principle according to which both Catholic and Protestant states were to be accommodated within the Western Roman Empire. But there was, and so if you like, this was an act of peace. But at the same time, it required that all the inhabitants of one particular kingdom, and there were about 350 in Germany, Germany was absolutely much more divided than Italy before unification. So if the king was a Catholic, all the citizens of the kingdom were Catholics. If the king or prince or archduke was a Protestant, automatically all the citizens were. And this is, I would say, a great symbol of the quest for uniformity of the nation state. And mind you, the same principle of cuius regio eius et religio was also formalized in the Treaty of Westphalia, 1648, which, as you may know, and if you don't know, you know now, is conventionally established as the beginning of the process of establishing nation states in Europe. So the nation state is a typical product of the Peace of Westphalia, which incorporated the principle of automatic uniformity of religion. For a long time, minorities were either repressed or the state was indifferent to the existence of minority. We all know the Puritans that crossed the ocean and went to to the state, William Penn that established Pennsylvania, and all this story. Until the 20th century. In the 20th century, for the first time, after the First World War, in Poland and in Greece, and in the Second World War in Italy, regarding South Tyrol, you had international rules of guarantees of protection of national and language minorities. And then there has been a great season of production of rules, constitutional rules, but also international rules and rules of soft law, because of the transition in Central, Eastern, and Southeastern Europe. And there is this institution, OSCE, which is very active in the field of protection of minorities. And in 1993, I made a mistake here, the first meeting of the heads of state and government of the member states of the Council of Europe met in Vienna, and they made a declaration stating that protection of minorities is necessary for democratic security in Europe, precisely because the protection of minorities was so weak. You're too young, but there have been policies of ethnic cleansing in southeastern Europe in particular. So, and for the first time, European states, nation states, have given themselves a framework convention for the protection of national minorities. I have here taken some statements from the preamble. Again, the principle of democratic security. You can listen and read at the same time. But also they said that the effective protection of national minorities must respect the territorial integrity and national sovereignty of states. Now, this is fundamental because it enshrines the principle, if you like, according to which protection of minorities is compatible with what has been called the internal self-determination of minorities. Internal or domestic self-determination. In other words, constitutionally based domestic self-government is a way through which human groups or social groups are to exercise their right to self-determination, not by creating a new sovereign state, but by or through enjoying self-government and protection of distinct identities within the borders of a nation state. If some of you are familiar with the situation in South Tyrol, this is the situation. The special autonomy of South Tyrol is a kind of domestic self-determination of the German-speaking population, protected by the Gasperi-Gruber Agreement, which is an annex to the Peace Treaty 1946. And so this is the way that applies to Spain as well, for the Catalans and for the Basque. This is important because internal or domestic self-determination is an enrichment of the right to equality. The right to equality within the traditional concept of a nation state is based on uniform citizenship and ultimately formal equality. Whereas the protection of minorities within the constitutional framework requires a right to equality which is transformed into a right to diversity. Not uniform citizenship, but cultural citizenship, and substantive equality rather than formal equality. You see, if I'm a German-speaking person from South Tyrol, how do I exercise my equality, right to equality? By speaking Italian? So you're like all the Italian citizens, you speak Italian. But I'm German-speaking inhabitant. So my principle of equality requires the protection of my distinct identity, and so my equality is guaranteed if I'm free to speak German, not if I'm free to speak Italian. And so if I'm a Catalan or if I am a Basque. Of course, kin states have their obligations. Kin state is the state with which the minority has, let's say, a cultural origin. Italy is the kin state of the Italian-speaking minority in Slovenia and in Croatia, for instance. Now, the problem of the Basque and the Catalans is they don't have any kin state. There's no any Catalan nation state, there is no Basque nation state. So from this point of view, they do not have any support. The German-speaking population in South Tyrol has Austria as a kin state. Again, Italy is also a kin state, but Basque and Catalans do not have any. Now, the Spanish constitution, don't we have a bell? Doesn't ring? Just give me 2 more minutes. The 1978 Constitution of Spain has given a strong recognition of minorities' rights, also through self-government. In fact, the scholars have defined the regional state or regionalism in Spain as a quasi-federal arrangement, or as a regional-federal system. And in fact, I would say the provisions for self-governments are quite wider than in Italy, the 2 examples of regional state. With one exception, which I think is important to consider because it certainly contributes to understanding what's going on in Catalonia, which is the centralized control over economic resources. From this point of view, the quasi-federal or the federal national regional system, with 2 exceptions, the Basque Country and Navarra, because of historical reasons, has a very centralized control of economic resources. So, and of course there is a provision, which I think you have seen already, which introduces the principle of national solidarity. But you understand that when you read the obligation to national solidarity and you apply it to a national minority, the national is not the same. Because in the case of the Catalans, they consider that the national refers to the Catalan nation, not to the Spanish nation. So that, of course I'm being provocative, national solidarity in the case of Catalonia become solidarity with different communities. They do not have the same kind of bond that unite all the Spaniards who are not members of national community. So this is quite important, and certainly it has played a role in the development of the process that we are keeping under consideration. Shall we have 10 minutes then? I stop here, and we resume in about 10 minutes. In effetti sono molto indietro. Now, very quickly, let me just point out, and this would be the 3rd coordinate that I would like to put to your attention, that here we are in a typical situation which reflects Weber's constitution of the state as the entity which has the monopoly of the legitimate use of force. The state has the monopoly of the production of legitimate legislation and criteria of legitimacy within the system. We all practice in European states legal monism. We don't acknowledge forms of legal pluralism. So we are bound by whatever the state, of course through democratic procedure, in conformity with constitutional values, can do. Now, I take here one of the suggestions of the introduction by Professor Dani earlier this morning, and just to make clear that what the Catalans are trying to do, or have tried to do, and supposedly will continue trying to do after the elections of December the 21st, is to change the source of legitimacy. Initially through constitutional revision, as we have seen in 2004, at a later stage through secession in 2017, at the next stage through constitutional revision. In other words, as a constitutional revision of the Spanish Constitution, or the reform of the Spanish Constitution, would be an alternative to secession. But of course, what you need is the political consent necessary to achieve that. At the same time, having said that, let me also add that changing the source of legitimacy is something that you can put in a framework, in a different framework, only ex post facto, because of the principle of effectivity, which is one of the fundamental principles in public law. Only after things have been achieved you can say whether it is legitimate or not. Now, look at the United States. They rebelled against the British Crown. In fact, they were called rebels. George Washington was the head of the rebels. Had George Washington been taken as a prisoner, he would have been executed, most likely. Look at Kosovo. Serbia still has not recognized the independence of Kosovo. Mind you, Spain has not recognized the independence of Kosovo precisely because they are afraid of endorsing a process that might ultimately be reflected within Spain itself, obviously with regard to Catalonia. But now we know that after the opinion of the International Court of Justice, we can say that the declaration of independence of Kosovo is legitimate. And the same, Slovenia declared herself independent from Yugoslavia, and Croatia declared herself independent, and Macedonia. And then when there was a federation between Serbia and Montenegro, at some stage Montenegro declared itself independent. So such things receive a final sanction only by history and by the principle of effectivity, or if you like, political realism. Now let's proceed. Whatever solution will ever be found, it will be on some compromise, which means that both fundamentalisms will be somehow disappointed. But in these cases, you see, if we denounce the incapacity of both sides to reach a compromise, we cannot not look for a compromise, and the compromise is exactly pragmatism against fundamentalism. Let me make another example. For decades, the Dalai Lama wanted to achieve independence from China. A few years ago, the Dalai Lama changed the policy and said, we want an authentic autonomy within China. And this, of course, is pragmatism, or if you like, principled pragmatism. And I will quote here a statement on Catalan.
China and Spain, you need two to tango.
Yes, well, I mean, by all means. But at the same time, I would say also the spiritual leadership of Puigdemont is quite different.
Far below.
Yes, by all means, yes. Now, at this stage, I would like to quote a statement by the External Affairs Secretary of the Government of Scotland, and which I thought is very, very wise, and is precisely based on this pragmatic compromise that I'm somehow advocating. We understand and respect the position of the Catalan government, understand and respect. While Spain has the right to oppose independence, the people of Catalonia must have the ability to determine their own future. Today's declaration of independence came about only after repeated calls for dialogue were refused. This, by the way, is also the position taken by the president of the province of Trento and the president of the province of Bolzano. Now, more than ever, the priority of all those who consider themselves friends and allies of Spain, mind you, friends and allies of Spain, not of Catalonia, friends and allies of Spain, should be to encourage a process of dialogue to find a way forward that respects democracy and the rule of law. The imposition of direct rule, which is the suspension of autonomy, Article 155, cannot be the solution and should be of concern to Democrats everywhere. The European Union has a political and moral responsibility to support dialogue, to identify how the situation can be resolved peacefully and democratically. Now, I'm coming back to this in the end, but I thought it might be useful to quote this statement at this stage, because I would say it gives a very relevant frame for understanding what the way out can be. Now, let's see now some factors to be considered. Now we go more into details. The partial invalidation of the new 2006 Charter of Autonomy affected symbolic and material features of the Catalan minority self-government. And when I make reference to symbolic features, I speak of language and culture and identity. And when I speak of material features, I mean policy making, legislative competences, and financial autonomy, the regime of public finance. How much of the wealth produced in Catalonia should remain in Catalonia, how much should go to Madrid and be redistributed among all the regions of Spain. Now, the Charter of 2006 was approved, I mentioned that already, by the Catalan Parliament, September 2005, by the Spanish bicameral Cortes as an organic law of the state, 2006. Then it was approved by a regional popular referendum in June 2006, came into force as an organic act, and was sanctioned by the King on the 19th of July and was published on the official gazette. So, as I said, everything was absolutely regular. The Popular Party, Mariano Rajoy's party, raised a question of constitutionality of the draft in 2006 with regard to 114 provisions in front of the Constitutional Tribunal. 114 provisions. So that could be a good internship for you if you ever want to have a summer job. You can try to be hired by some Mariano Rajoy around the world, and there are always Mariano Rajoys around the world that will need the support of some legally trained minds. Now, the Constitutional Tribunal took 4 years, as I said already, to reach a non-unanimous decision, but then I'll be more accurate, which declared 14 provisions unconstitutional. So 114 challenged, 14 declared unconstitutional, 27 provisions were declared constitutional subject to one specific interpretation given by the Constitutional Tribunal. Have you spoken already of the sentenza interpretativa? No. It will come. It happens everywhere, also in Italy. The Constitutional Court says, this is constitutional provided you interpret it this way. If courts interpret it in a different way, then that provision will be, at a later stage, declared unconstitutional. So 114 unconstitutional, 27 provisions constitutional, but subject to one specific interpretation. And then in the preamble, the decision of the Constitutional Tribunal declared void of legal effect references to the Catalan nation, nation-state, nationality.
Nation and non-nationality.
Yes. Oh, yes, absolutely. Now, just for your information, the decision was a unanimous decision on the declaration of unconstitutionality, which means that all the members of the tribunal shared the same assessment of unconstitutionality for those 14 provisions. Whereas on the declaration of constitutionality, that means rejecting the 100 remaining challenges by the Partito Popular, the decision was taken by a majority. And it is fair to say that the dissenters wanted to declare those provisions unconstitutional. So if you like, there is a strong assessment or a wide assessment of unconstitutionality of the Charter. You have 5 individual decisions of those who did not share the view. In Spain they call it votos particulares, and they're not translated into English. So the decision is translated into English. It's 546 pages, if you ever care to read them. It is very interesting, but extremely boring, of course. Well, I mean that you have a good, unless you don't have a strong motivation, you will never read this decision. 440 pages, I mean, that's ridiculous. Now, what was the reaction against the decision by the Constitutional Tribunal, which I tried to explain to you, was som una nación, nosaltres decidim. So in other words, this was, I would say, the first break away from the rule of law. We don't care about the judicial decisions. This is a violation of the will of the people, and ultimately it is a violation of the sovereignty of the Catalan people.
And was this the Catalonian government?
Yes, yeah. Yes. Som una nación. So let's see some of the declaration of unconstitutional. The preamble. Now, the preamble, I would say, is a very elegant exercise of, how do you say when you ski? You do the slalom. This is a fantastic slalom, I would say, between acknowledgement of the Spanishness and emphasis on Catalan identity. Now, I can read the whole thing because, of course, we don't have the time. But you see, the green is pro-Catalonia and the yellow is pro-Spain, just to give you an idea. Here they recall the recovery of the Generalitat with the 1932 Statute of the Second Republic, the re-establishment of the Generalitat in 77 and 79 Statute, coinciding with the return of democracy, the Constitution of 78, and the state of autonomy, el Estado Autonómico. I'm sorry. The Generalitat is the institutional form that since the 15th century Catalans have had. It's the name of their institutions, which is at the same time Catalonia as a country, if you like, but the institutions of Catalonia as a country. Now, the 1979 statute acknowledges the same traditional name of Is anybody from the Val di Fassa from you? No. No Ladini. You are? All right. Well, then I'm afraid this doesn't apply. But in Val di Fassa, which is the valley of the Ladino population in Trentino, they have established one institution which is called Comune General. And although there are 7 municipalities, they call the shared institution, the valley institution, Comune General. So this is a traditional name which also the population of the Val di Fassa wanted to adopt when they gave themselves a statute. I don't think you have the same in Val Badia. No, right. Okay. Let's continue with the preamble of the Charter. You see, at some stage they say, in solidarity with Spain as a whole and incorporated into Europe. Of course, incorporated into Europe is more important, I would say, for the Catalans than being in solidarity with Spain. And yet, they write in the preamble, in solidarity with Spain. Catalonia self-government is founded on the Constitution. Now, this is very important, because I myself had once a quarrel with a colleague in Barcelona, because I said that the autonomy of Catalonia is founded on the Constitution. And he said, no, absolutely. It is founded on the historic right of the Catalonian people. So irrespective of the present foundation of self-government. And in fact, you see, and also on the historical rights of the Catalan people, also on the historic rights. But the Constitution comes first. But you see the slalom, which in the framework of the Constitution, again, give right to recognition in this statute of the unique position of the Generalitat. Catalonia wishes to develop its political personality within the framework of the state, which recognizes, and I read it here, as long as it recognizes, a sort of condition that is put to the development of personality of Catalonia. Catalonia, by means of the state, participates in the construction of the political project of the European Union, whose values and objectives it shares. So it's not that as part of Spain, Catalonia is part of the European Union, but through Spain, Catalonia participates. So you see how the wording is very accurate, and as you see that in Italian I would say dare un colpo al cerchio, un colpo alla botte. It tries to keep both sides appeased. And then here comes, this is the hard part. In reflection of the feelings and the wishes of the citizens of Catalonia, the Parliament of Catalonia has defined Catalonia as a nation by an ample majority. And if you read the text of the preamble on internet, you will find the footnote number 1, which will say this reference from the preamble has no interpretative legal effect in accordance with the decision by the Constitutional Court. In other words, this has no legal relevance. It is just a statement. And here the quotation is to Article 2 of the Spanish Constitution, which recognizes the national reality of Catalonia as a nationality. Again, the accurate use of words. Now, lawyers are, I would say, the best manipulators of concept through the use of words. And this is a very good example. The national reality of Catalonia as a nationality. Now, as a nationality combines with Article 2 of the Spanish Constitution, the national reality of Catalonia combined with the historic rights, the claims, the wishes, the desires of the Catalan population. And again, you find footnote the reference has no interpretative legal effect. And you have already familiarity with Section 2 and this very unique use of nationalities and regions. And you see, that's what is very interesting, also because I have to, this is the importance of language, which is very important in particular, because you are within the cage of the English language, and of course you should know more languages. That's my support for your commitment to the study of languages. You know that in some languages of some countries, there is a distinction between nationality and citizenship. Not in German, not in Italian, in English, in French, and in Spanish. So in Spanish, nacionalidad means that you are part of the nation, even though you are not a citizen. Just as national, citoyen. The point is that, so in Spain, nacionalidad, singular, has one specific meaning, but you don't have to translate it into the plural, because in the plural, nacionalidades is something different. And in fact, when it was written in the Constitution in 1978, nobody knew what it meant. Now, nacionalidades is a way to acknowledge the quasi-national status of some language groups. So they say we cannot say...
Just regions. You cannot say just regions.
Yes, exactly. So if we speak of a Spanish nation, and because we are a nation state, we cannot ignore the Spanish nation. But then how can we say that the Catalans are a nation? So we must find a new word. And the new word that they found was nacionalidades at the plural. Mind you, because if you say nacionalidad, singular, it means nationality distant from citizenship. So that's the way, again, this is pragmatism. This was a compromise that allowed the ruptura pactada, of which I have spoken earlier today, and but this is the text, and of course the Constitutional Tribunal has to deal with the text. Now, Professor Victor Ferreres Comella, a very fine jurist from the Pompeu Fabra University, has written with regard to this part of the decision. The court in particular was rather clumsy when it refused to give its constitutional green light to the idea that Catalonia was a nation, an idea that the preamble of the statute expressed. In other words, Victor Ferreira says, who cares? If this is important for the Catalans, let them have it. This will not really change substantially any particular legal relation. But of course, in the Constitutional Tribunal, you have the Spanish nationalists, and of course the Spanish nationalists will not give way to Catalan nationalism. So the compromise that you had at the Constituent Assembly, you did not have in the decision by the Constitutional Tribunal. And again, in Article 6 of the Charter, you have Catalonia's own language is Catalan. As such, Catalan is the language of normal and preferential use in public administration bodies and in the public media of Catalonia. Now, the expression preferential has been declared unconstitutional. So here you cannot have any legal effect. And what the court said, in other words, is that I have put here, this part has been translated into English, the question relating to the constitutionality of the status imposition of the duty to know Catalan must be resolved based on the principle that said duty is not imposed by the Constitution and is not inherent to the co-official nature. So in other words, the regional charter cannot impose a constitutional obligation to learn Catalan. If you are a Spanish citizen or if you are a foreigner, you don't have to learn Catalan. And in fact, at the end, it says, Article 6.2 of the statute would be unconstitutional and null if its intention was to impose a duty to know Catalan equivalent in meaning to the constitutional duty to know Spanish. The provision naturally allows a different interpretation in accordance with the Constitution, a provision that sends a mandate to the public powers of Catalonia to adopt the measures necessary to facilitate compliance with this duty. So you see the interpretive decision. It is not an obligation to individuals, it is an obligation onto the Catalan authorities to provide the means to allow everybody to be able to learn Catalan. Now, let's come to the final part. Is there any realistic perspective for a dialogue? Which, I mean, as long as we agree that a dialogue would be the proper way of getting out of the constitutional crisis in order to solve the Catalan question. Of course, we have to face the uncertainty over the electoral results of the December elections, December the 21st, 21st. That would be absolutely, well, that would be typical of Mariano Rajoy, I would say, because he doesn't celebrate. Anyway, so tonight, as I said, is the deadline for producing the list, so tomorrow morning do read the newspapers and try to find out who is going to be there. Now, one of the problems that the three independentist parties have been considering in this last week has been whether to present one unitary list or three separate lists. Now, officially, of course, you can never rely so much on what political parties tell you, but they say we all share the same goal of quest for independence, but we know that by introducing one list only, we would lose votes. Whereas if we present our own individual list, we will sort of keep our voters, those voters that would not vote because they don't like the other partners. So at the moment, the perspective is that we are going to have three independentist lists. We shall see tomorrow morning. Of course, there is on the side of the national government an expectation of reduced consent for independentist parties having regard to the consequences of the judicial proceedings. So, if I would say the elections will affect the possibility of having a dialogue, of course I would say that if there is a clear-cut majority supporting independentist parties, the national government will have to do something. Second point, should dialogue include a negotiated exercise of the right to decide without any automatic secession? So just a referendum, sort of an opinion poll. Of course, if we look at the Canadian example and if we look at the British example, respectively with Quebec and with Scotland, this might be possible. Of course, in Southern Europe, we are quite different. And I don't think that they will go that far. Of course, on the other side of the compromise, you must have relevant amendments to the Constitution in order to accommodate the quest for more autonomy in the Charter. The next steps of the judicial proceedings in Spain and in Belgium. Now, this is interesting. Now, I'm quoting The Guardian from yesterday. Late on Sunday, a Belgian judge granted the Puigdemont and the four councillors, conditional release Now, what is interesting is that in spite of the European arrest warrant, it seems that they will need at least 2 months before the Belgian authorities may order Puigdemont and the other 5 to leave Belgium and go back to Spain. Now, this would take place after the elections. And I'm quite sure that this is what those guys want, to be able to go back to Spain and see if the criminal judicial proceedings will continue as if there had not been any electoral result. Now, this is not the legal approach to the question, but certainly it is a political and, if you like, smart or opportunistic way of looking at it. Fourth point, the attitude of the independentist leaders, which doesn't help much. So, I mean, you have a hard-headed Mariano Rajoy, and you have a hard-headed Carles Puigdemont, who has accused this, again, the Guardian from yesterday, has accused the Spanish authorities of conducting a brutal judicial offensive against members of his ousted government, and said he was afraid they would not receive an unbiased hearing in Spanish courts. Now, for the second part, I may almost agree, but not for the first part. I wouldn't speak of a brutal judicial offensive. The point is that they had no choice. They don't have the mandatory judicial prosecution as we have in the Italian constitution, but there was no doubt that the law had been violated. Writing in The Guardian, Puigdemont said it was a colossal outrage that he and 13 colleagues were being investigated over possible charges, including sedition and rebellion. These are crimes that normally are enforced against terrorists. That was the case of ETA and the Basque terrorists, whereas in Catalonia, violence has never been used. So you understand, again, politics and the law. There is something wrong if the same rules are applied to terrorists and to non-terrorists. And Puigdemont said he doubted that he and his colleagues would get a fair and independent hearing and called for scrutiny from abroad. This, again, is an issue. Any role from abroad. Now, Professor Shining from the European University Institute said, under international law, it does have the right, Catalonia does have the right to present such claims, which, if emerges through a referendum or other inclusive process of consultation, would need to be addressed on the merits by Spain and by the international community. This is a blog of his, and he said the purpose of this blog is to explain why blanket references to the Spanish Constitution or to the principle of territorial integrity of states are not valid excuses for not addressing the claims. Now, he doesn't speak of a right to secession, but he speaks of a right to decide, the right to be given a chance of expressing their will, which is, if you remember, one of the first initial stages of the whole process. Now, I have prepared here, again from The Guardian, I would say a very unrealistic picture beyond Catalonia, pro-independence movements in Europe. Now, okay, the Faroe Islands and Scotland and Northern Ireland and Wales, but Brittany, I don't really see any. Corsica, Sicily. Now they have a brand new governor. I mean, why should Sicily?
And independent got 1%.
And independent got, yes, 1%, that's right. Lombardy and Veneto, again, I mean, that's quite ridiculous. I'm really disappointed at The Guardian. South Tyrol, of course, there is, but Trentino, as you see, is faithful to Italy. And many people in Trentino would not be so happy about it. Bavaria independence from Germany? Now, I don't know about Bornholm, but that's not my great worry. Upper Silesia, Moravia, Czech Silesia, I mean, Istria. Of course, there is a party, but there's no, there's no. So I show this because you see that sometimes, there are some exaggerations, so that I don't really think that the international community is so concerned of what might happen.
Strangely enough, they didn't put Sardinia, which has Catalan minorities
Yes.
who sympathized with.
That's right. You should write a letter to the Guardian.
I'll ask Paolo Carta.
Yes, that's right. That's right. But yet, I would say there may be an interest of the European international community and of individual member states to keep the Catalan situation under control for fear of widened attempts at breaking away from nation states. Now, of course, I don't share the view of the Guardian, but I would say ultimately that there is such a European interest. I already recall the principle of European democratic security, remember 1993, which I mentioned earlier today. And we may be, of course, I don't think that in Catalonia there will be any violence, but still the situation may become quite unmanageable also from the civilian point of view. Now, what about the European Union? Now, let me just mention again an expert, Gideon Rachman from the Financial Times, which says the EU is politically and intellectually unprepared for a crisis in Spain. It is not prepared for whatever happens in Hungary, whatever happens in Poland, and in other parts of the world. Catalonia's bid for independence demonstrates that traditional questions of nationhood and sovereignty can still stir the blood in modern Europe. Now, don't forget that in Britain, they are really facing a crisis. Scotland, Northern Ireland, and Wales. There is also a possibility that the crisis could lead to violence between the Spanish central government and pro-independence forces in Catalonia. I don't think this is the case. But then I think that the final remarks is interesting when he says the question for the EU elite is whether a relaunch of the Franco-German partnership is the indispensable step needed to save the European project or an introspective evasion of other more troubling problems. Europe's leaders would like to ignore the crisis in Spain, but the Spanish crisis may not ignore them. So I personally expect some opening from the European Union and from the international community in general. This might be, let's say, a good push for the fundamentalists of both sides to sit around the table and try to negotiate a compromise. I'll stop here. Sorry for being so long, but it's a long story.
I would like to thank Professor Roberto Toniatti for this lecture, which was very rich, and I would say in the end optimistic. Mm-hmm. He offered an account for the crisis that with this call for pragmatism and compromise, which is, as I told you from the start of this course, a good word in constitutional law. Compromise is not something that should be despised or set aside quite easily, could offer a venue for resolving peacefully the crisis. If I can just make a qualification of his optimism, I think that the European Union could enter in the scene if the elections will go in a certain way. So if the independentists will win. Otherwise, I think the crisis will be resolved just by enforcing the current Spanish constitutional order and dealing with the dissidents. If you have questions, I think we can have other 5-10 minutes. Yes, please.
I have a question regarding routine toward minorities' rights? I mean, isn't it too strong to enact this article, so the suspension of self-government in this case? Is not too much?
I don't think so. Now, first of all constitutions having some decentralization have the same kind of provision. We have it also in the Italian constitution. You may know that. So that it is sort of a routine provision. You always write it because you never know what could happen. And I'm quite sure that when it was written, there was no idea that it would be ever applied. But now the case comes, and I would say that it has some provisions of guarantee inside, procedural guarantees. Of course, remember what I said about Weber and the monopoly of legitimacy. If you have the majority in Parliament, then you can have free way. Yeah? I don't think so. This would meet your perplexity. I don't think that there has been a misuse of Article 155. I mean, what do? If they have declared that Catalonia is not Spain. They have declared that Catalonia is an independent state. They were going to elaborate legislation that should replace Spanish legislation. I don't really see any alternative. So I don't think it is too strong.
Are you aware of initiatives to challenge the use of, judicially, the use of Article 155?
I don't know whether this has been exercised already or not, but there were talks about it. But you see, the point is, it all depends on the discretionary assessment of the situation. It's like Article 7 of the Treaty of the European Union, seriously prejudicial to the general interests of Spain. It's very vague. All provisions. If you go through emergency regulations in constitutional law, let me give you an example. Article 19 of the French Constitution. It says when there is a danger to the territorial integrity of France. Now, what is a danger? Of course, the point is a judicial institution, in particular a constitutional court, able to review the political evaluation? Look at it. Do you know already decreti legge? No, not yet. But you will see, that the Italian executive, Article 177, can adopt decree laws that have the force of a law. That means that can change and reform any legislation and will have to be transformed into law by Parliament within 60 days. And this can be done only in exceptional situations of emergency. Now, this is a political evaluation. In the United States, the Supreme Court has elaborated a doctrine of political questions. In Italy, we don't, and in fact, the point is still open to what extent the court can evaluate whether there is a serious emergency or not. The court has said yes, but that was because of the wrong use of the decree law. Should Italy be invaded by the army of Dubai, and I don't think that the Italian Constitutional Court would invalidate the decision by the executive. There is another question.
I have a question about the king's rule. So, the king's rule, according to you, can have the king a useful role in this Catalan question, or he should remain outside this?
Well, I'm afraid he lost his chance of having a role because he already has played a role. You know certainly that he gave a speech, and it was called. He is called now el Rey del Partito Popular, the King of the Popular Party, because his intervention was completely one-sided, and I would say that he missed the chance of being able to play a role in promoting dialogue. He did not do that, and I think that this he was very different from his father, who played a very important role in the defense of democracy. There is one more there.
Yes.
No, you don't agree with that.
On the role of the king defending the democracy, I'm not sure. He has been part of the Tejero.
No.
If you read certain accounts, he sympathized with those who supported Tejero in the 1981 coup.
Yeah, but then, dai nemici mi guardi Dio, dagli amici mi guardi Dio, che dai nemici mi guardo io.
Perhaps.
Because he prevented the coup d'etat from continuing.
In the first part of the transition, he has been very. He played a proactive role to introduce democracy for sure.
Yeah.
But then he abandoned Suarez and he sympathized with those against him in the 80s. Yes, please. Two questions.
Why there was a different position of the European Union on the situation in Kosovo and about the situation in Catalonia? Why there was a different answer?
Now, the situation in Kosovo was at the end of a bloody war, and you know that there has been a military intervention in Serbia with bombing of Belgrade, so that it was acknowledged since the beginning as an international crisis, which is exactly the opposite of what is being said concerning Catalonia, which is always regarded, and there are public statements to that effect, as a domestic affair of Spain.
Regarding the economic welfare of Catalonia, wouldn't independence from Spain be a threat? And maybe the exit from the European Union, which would come with the exit from Spain, affect negatively the whole economy of Catalonia?
Yes, as long as Catalonia would not be admitted as a new member into the European Union.
Spain, I think Spain accepts Catalonia as a member of.
Well, I would say that there will not be any independence of Catalonia without involving the government of Madrid, and the involvement of the government of Madrid would include Catalonian membership in the European Union.
But if they're working this hard against the central government, I don't think they could ever achieve some compromise where they stay in the union without a total revolution.
Yes, but then let me ask you, what is the alternative to a compromise? Military repression, police? We're talking of millions of people.
Yes.
That's why I say it cannot be only a legal criminal matter. It is a political issue. Of course, the government has been very able in order to not let any political dimension come out. But I would say one of the reasons why this strange person like Puigdemont went to Brussels is one further attempt to try to externalize the whole situation. So I would say that Catalonian membership will be part of the package if there will be any package at all. But without the package, what is the solution?
So you completely exclude the possibility of a revolution in Catalonia?
An armed revolution? Absolutely not. of course, maybe, it's just my personal feeling, and I don't believe there could be, and I hope there will be no, small groups that may attempt to do that, but that would be so much in the interest of Madrid that nobody, and paradoxically, the brutality of the police here, I would speak of brutality. The brutality of the police gave a very bad image on the government of Madrid. Although some sources in Catalonia say that there have been only 3 or 4 violent uses of the force by the police, and the fact that the television was there to take the images perhaps is a sign that it was well organized. In other words, this gossip, of course. When somebody say, well, we knew that by showing the brutality by the police, we would get some support by the international community. So let's do it on purpose and make sure that the camera is there.
Okay, thank you very much for your attendance, and I'll see you tomorrow at 11. We'll start again with the form of government.